My question is, how are those students going to be made whole if you are not allowing the university to pay the fines? What's the plan?
I'm not sure that that's the right analysis of it.
A congresswoman walks into a hearing room ready to prosecute the education secretary on fraud, ethics, and student protection. She brings up a rescinded fine, a backlog of defrauded borrowers, and even takes a shot at a former president's now-defunct university. All of that in one hearing. But here's the part nobody is talking about. The person asking all those questions about institutional fraud has her own financial story that raises a whole different set of questions. Stay with me until the very end, because the contrast in this clip is something you need to see for yourself. And if this kind of unfiltered breakdown is what you've been looking for, hit that like button and subscribe before this video is over.
And I recognize now the gentlelady from Minnesota, Ms. Omar.
Thank you, Chairman, and thank you, Madam Secretary, for being here with us. Is it fair to assume that you are aware that when a student loan borrower is defrauded by a school, that there is a provision in law called the borrower defense?
Yes, I am.
Okay. It is a straightforward concept. A student should not be forced to repay loans to schools that lied to them. We know that millions of federal grants and loans go out the door while students are left with education that is not worthy. So I was actually surprised a few weeks ago when your department quietly rescinded $37 million fine that was placed against Grand Canyon University. Can you explain why that happened?
Let me think for a second. Let me review my notes on that because there were a couple of things I wanted to make sure I covered with you. We really found that the accusations against Grand Canyon, which is a faith-based organization, and we looked at all the facts of the case.
I am familiar with the university.
Really,
my question is, how are those students going to be made whole if you are not allowing the university to pay the fines? What's the plan?
I'm not sure that that's the right analysis of it, but I will look into it further and get back to you.
And you'll give me back a writing?
Yes, I will.
Writing? Okay. Because we know that, you know, the president in whom you serve had a fraudulent university called Trump University, and he himself settled 3 lawsuits before becoming president. We know that there are roughly 1.4 million borrowers who have been approved for a borrower defense discharge and are still waiting for that process. How are you clearing out that backlog?
In terms of the borrowed defense funds?
Uh-huh.
You know, there are lists of that. I'll be happy to get back to you with those numbers.
Okay. And while those students wait, can you give us a commitment that you are not going to collect that debt?
Yeah, I'll have to get back to you on that as to what the situation is. And
I don't understand how that's a difficult question to say yes to. They've been defrauded. They are waiting for relief. While they wait for their relief,
Well, if
they shouldn't have to pay back that debt.
well, if they've been defrauded and it's been adjudicated that they've been defrauded, then I will get back to you as to what the time frame is and why there's a holdup if there is.
Okay.
I'm not sure as I sit here right now.
Wonderful. There was, I know that you've been questioned a lot on IDEA and its funding. I won't re-litigate those questions. I just have 2 particular questions to address, or 2 areas to address. We know that the IDEA, that you have gotten rid of the legal team that guides the states in implementation. How are you going to rectify that?
I don't know what you mean by we've gotten rid of the legal team. We have had some reduction in force of
There was a
members.
firing of the entire legal team.
Well, we have other lawyers in place at the Department of Education, and we are
The
fully...
entire team that was for IDEA has been fired. So how are you addressing that?
Because we have other lawyers who are in place that can handle those things. And as I mentioned before, we have not missed any of our statutory requirements.
I do believe that that firing hurts the implementation. We also know that you have gutted the Office of Civil Rights when there is already investigation backlog. How are you going to fix the discrimination claim cases that are out there?
Well, there are, excuse me, there are cases that we're looking into. And again, we have not missed any of our statutory requirements in terms of OCR. We also have a task force.
There is a backlog. There are a lot of
There is a backlog
There are a lot of
because we
kids in our schools that are waiting for relief. When you get rid of the people that are supposed to carry out those investigations, how are you to assure that those kids will not continue to be harmed? We are talking about so many situations in where kids are being discriminated against, and you got rid of the people that investigate those investigations so those kids can protect themselves from from discrimination.
Well, we still have a very strong and capable staff in OCR. At the
Then
Department
you
of
wouldn't have a
Education.
backlog if that was the
No,
case.
the-
There is a current backlog, and
Well,
I
excuse
would
me.
There is a particular kind of political theater that only works when nobody checks the background of the person performing it. What you just watched was a congressional hearing exchange between Representative Ilhan Omar and Education Secretary Linda McMahon. And on the surface, it looks like aggressive oversight, a lawmaker holding a cabinet official accountable for decisions that affect millions of student borrowers. That framing is compelling. But when you pull back the camera and look at the full picture, something else comes into focus entirely. Start with the actual policy question being raised, because it is a legitimate one. Borrower defense is a real provision in federal law. It exists specifically to protect students who were deceived by institutions that made false promises about job placement rates, accreditation, or educational quality. The concept is not controversial. If a school defrauded a student, that student should not be left holding the bill. That is a principle most people across the political spectrum can agree on. The specific flashpoint here was the Department of Education's decision to rescind a $37 million fine that had been placed against Grand Canyon University, a faith-based institution based in Arizona. Omar wanted to know why. McMahon's answer was that the department reviewed the fact of the case and determined that the accusations did not hold up. She acknowledged the organization's faith-based character, which is relevant context when you understand that the prior administration's enforcement actions against faith-based institutions were scrutinized by critics for selective targeting. McMahon did not give a complete breakdown of the legal analysis on the spot, but she committed to following up in writing. That is a standard and appropriate response for a complex regulatory matter raised in a public hearing. Now here is where the hearing gets interesting. Rather than pressing deeper on the legal specifics of the Grand Canyon case, Omar pivoted to Trump University. She brought up the fact that the former president settled lawsuits connected to that institution before taking office. That move is worth examining because it tells you something about the strategy. When the specific case you came to argue starts getting complicated, you reach for a broader emotional reference point. Trump University is a well-known political flashpoint. It lands easily. It does not require explanation. But it also does not have anything to do with whether Grand Canyon University's fine was rescinded appropriately. The borrower defense backlog question is more substantive. There are reportedly over 1 million borrowers who have been approved for discharge under borrower defense provisions and are still waiting. That is a real problem regardless of which administration created it or is now responsible for resolving it. McMahon's response that she would look into the numbers and get back with specifics is the kind of answer that frustrates people in these hearings, and for good reason. When you're running a department and you're called before Congress, you should know the status of a backlog that large. That is a fair criticism. The ideal legal team question also deserves a straightforward look. The Individuals with Disabilities Education Act carries strict federal compliance requirements. If a specialized legal team that guided states through implementation was significantly reduced or eliminated, there's a legitimate question about whether those compliance obligations can still be met effectively. McMahon's answer that other lawyers remain in place to handle those responsibilities is the kind of response that needs to be verified, not just accepted. Follow-up matters here. The Office of Civil Rights backlog raised at the end of the exchange is similarly real. Civil rights investigations tied to discrimination complaints in schools are not abstract. They represent children waiting for determinations that directly affect their access to equal education. When staffing is reduced in the department responsible for those investigations, the question of whether existing cases will be resolved in a reasonable time frame is entirely valid. So, let us be clear about something. The policy questions Omar raised are not frivolous. They are real issues that deserve real answers, and McMahon would have served the moment better by arriving with more specific data points on each one. But here is where the commentary has to be honest about the other side of this picture. When a public official steps into a hearing to question someone else's ethics and institutional integrity, their own record enters the room with them. Omar's campaign finances have been the subject of extended public reporting and federal scrutiny. Payments from her campaign to her husband's consulting firm running into the millions of dollars have generated questions that have not been fully resolved in public discourse. The sudden valuation increases in connected financial ventures have raised eyebrows from investigators and journalists across different outlets. None of that is alleged without basis. It is documented in campaign finance records and has been covered by reporters who cover both sides of the aisle. That does not mean Omar has been found guilty of anything. It does mean that when she positions herself as the ethical authority in a room, the audience is entitled to hold that positioning up against her own publicly documented circumstances. That is not a partisan point. That is a basic standard of consistency. The measure you use to judge others must be the same measure you are willing to apply to yourself. When it is not, the oversight loses its moral weight, even when the underlying questions are legitimate. McMahon's handling of the hearing was steady. She did not get drawn into the Trump University detour. She did not become defensive or reactive. She acknowledged what she did not have immediately available and committed to follow-up responses. In a hearing environment designed to produce pressure and stumbles, composure is itself a substantive response. What this exchange ultimately reveals is not a clear villain or a clear hero. It is a window into how Washington actually functions. Real policy concerns get mixed in with political positioning. Legitimate oversight shares floor time with calculated rhetorical moves. And the people asking the questions are sometimes carrying the same kind of baggage they are accusing others of hauling. Watching this without understanding all of that context gives you half the story. Watching it with full context gives you a much more honest picture of what American governance actually looks like in practice. And that honest picture is the only one worth having.